Before you today on State versus Antonio, I ask you file 25 CR 410. We're here today for a change of plea. It's anticipated by the state of Ohio the defendant withdraws previously entered pleas of not guilty and enter pleas of guilty to counts 1, 4, and 5. And in exchange, the state of Ohio will ask you to nullify the remaining counts at sentencing, other than a pre-sentence investigation report. No threats or promises were made to this defendant to induce his plea. Thank you.
Mr. Kuharski, does that sound accurate?
It does, Your Honor.
Thank you. Excuse me. And Mr. Askew, you were able to hear what the prosecutor just had to say regarding what he believes your intentions are here this morning?
Yes, sir.
He indicated to this court he believes it's your desire to withdraw your previously entered pleas of not guilty and plead guilty to 3 counts of this indictment, counts 1, 4, and 5, and I'll go over those with you to make sure you understand them. The remaining counts would get dismissed. We would defer sentencing to a later day to get some evaluations completed, come back on a future date for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties that you face. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right? You have to say yes or no for the court.
Yes, sir.
Thank you. All right, well, let's get started then. How old are you, sir?
54.
I'm sorry?
54.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No,
Not
sir.
not even prescribed medication, nothing?
No, sir.
Now, you should have received a copy of this indictment. Looks like you got it sometime maybe about the middle of April this year. That's the document that sets forth the specific charges you're accused of committing. Do you remember getting that at some point?
Yes, sir.
And did you have a chance to look that over?
Yes, sir.
Now, in that indictment, you're charged with 6 separate offenses. You're pleading guilty to 3 of those, so I'm going to go over those 3 charges with you. Again, if you have any questions, make sure you ask. But in count 1, what's alleged here and what you're admitting to is on or about November 25th, 2024, in Fairport Village, Lake County, Ohio, that you didn't knowingly sell or offer to sell cocaine or some compound mixture, preparation, or substance containing cocaine. The amount involved did not equal or exceed 5 grams, was 0.47 grams, which makes the offense trafficking cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, sir.
Any questions about it? Now, count 4, next count you're pleading guilty to. What's alleged here and what you're admitting to is on or about December 20th, 2024 in Fairport Harbor Village, Lake County, Ohio, that you did knowingly possess or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount involved equal or exceeded 5 grams, but was less than 10 grams. It was 8.49 grams, which makes the offense possession of cocaine a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in count 4?
Yes, sir.
Any questions about that?
No, sir.
Now, in count 5, what's alleged here is on or about December 20th, 2024 in Fairport Harbor Village, Lake County, Ohio, that you, not having been relieved from disability under operation of law or by legal process, that you knowingly acquired, had, carried, or used a firearm or dangerous ordinance, and that you were under indictment for or previously been convicted of a felony offense involving the illegal possession, use, sale, administration, distribution, or trafficking in a drug of abuse, that being possession of cocaine, and here in the Lake County Common Pleas Court back on October 20th of 2009. That conduct constitutes the offense of having weapons while under disability. It's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in regards to count 5?
Yes, sir.
Any questions about that for me?
No.
So you understand the nature of the 3 charges you're pleading guilty to?
Yes, sir.
Now, there are 3 other counts in this indictment. Those are all being dismissed pursuant to the agreement reached by your lawyer with the prosecutor. Is that your understanding?
Yes, sir.
Do you have any questions about those 3 charges that you'd like to ask?
No, sir.
Well, then before I can accept your plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have the right to have a trial in this case. Now, the trial could be to me as a judge, where I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial could be in front of, or would be in front of, 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those 12 jurors would consider and weigh all that evidence. Then those jurors will make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision. What that means is all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, sir.
Now, if we did have a trial, you'd have the right to have an attorney represent you at that trial. And if you cannot afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, sir.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it's his job, or he bears the responsibility, the obligation to prove you guilty at a trial before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden of proof we have in our justice system. What it means, it's the amount of the evidence and the quality of that evidence that the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of these charges beyond any reasonable doubt before you can ever be found guilty at a trial of any of these charges. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
Now, in order to try to do that, if we're going to have a trial in this case, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. And we call that cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here to testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request this court issue an order and call that order a subpoena. What a subpoena would do is it would force or make someone come to court to testify for you and answer your lawyer's questions if anyone was not willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision. That's a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's solely your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, he's not allowed to call you as a witness and make you get up on the stand and testify and answer questions. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
You further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
All All right, well, do you have any questions at all about these rates we've just discussed? These are all the rates you have and all the rates you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Do you understand a guilty plea is a complete admission of guilt? That means you're admitting to the facts that are being alleged here by the prosecutor. We're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty to 3 charges here. Count 1 is a felony of the 5th degree. That's the trafficking cocaine charge. That carries with it a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir.
Now, count 4 is the next count you're pleading guilty to. Possession of cocaine is a felony of the 4th degree. This carries with it a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, sir.
Lastly, count 5, the weapons under disability charge is a felony of the 3rd degree. That carries with it a possible term in prison of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, or 30 months. So if I impose the prison term on that count, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you have to serve for that count. Do you understand that?
Yes, sir.
Now, since we have 3 separate charges here, if I imposed a prison sentence, I impose it on each count, and then as the judge, I have the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means you'd serve those counts at the same time, together at the same time. Consecutive means you'd serve those counts one after the other. You'd serve the prison term on the first count, complete it, then the next count, etc., for whatever counts are consecutive. Do you understand that?
Yes, sir.
So in this particular case, if I imposed a maximum sentence on each count and ran them all consecutive, you're looking at a maximum possible prison term in this case of 66 months or 5.5 years in prison. Do you understand that?
Yes.
Now, are you currently on probation or parole to any other courts or agencies?
No.
Do you have any other charges pending against you anywhere?
No.
If a prison sentence were imposed in this case at any point, upon your release from prison, you could be placed on what we do call post-release control. We sometimes call that parole. It's a period of supervision you'll be on after you served and completed whatever the prison sentence was. And in this particular case, it could be up to 2 years. Do you understand that?
Mm-hmm.
And if you were on post-release control and ever violated any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. Strike that, I jumped ahead. If you were on post-release control and you ever violated their rules, the parole authority would have a hearing and they could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term is imposed by the court. Do you understand that?
Yes.
Now, aside from the possible prison sentence that I just mentioned, there's other sanctions that could be ordered. You could be fined in this case. Count 1, the trafficking charge carries with it a possible fine of $2,500. Count 4, the possession of cocaine charge carries with it a possible fine of $5,000. And the weapons charge in count 5 carries with it a possible fine of up to $10,000. So altogether, there's a maximum fine of $17,500. Do you understand that?
No, sir.
You could also be ordered to pay court costs or reimburse the county for any costs of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, sir.
I also have the discretion, it's not mandatory or required, but I could suspend your driver's license up to 5 years. Do you understand that?
Yes, sir.
And the paperwork shows there's a voluntary forfeiture of not just the drugs, but some money and phones. Is that correct?
In firearms, yes, Your Honor.
Is that accurate?
That is accurate, yes, Your Honor.
And you'll be agreeing on sentencing to forfeit those items, Mr. Askew?
When forfeiture with firearm, I never had it. It's not my gun. So.
Right.
Well, the
Right.
way that works, I'm sorry, any right, title, or interest you have in the firearm. If you don't have any, then there's nothing for you to forfeit. But if you do have any ownership interest in it, it would be forfeited.
No.
Well, I'm just telling you that's what that means.
Yeah, do you agree?
So that any property they seized at the time, they include that, and if you don't have any ownership interest in it, then it's irrelevant towards you.
Exactly.
But there is some money and phones apparently as well.
No, they didn't. They never took my phone. They never took my phone. I got that.
Well, then why
I
is
kept
the
my
phone
phone. They
listed
never
in
took
there?
my phone.
You said they took it. It's
No,
a
they-
phone that,
They never took my phone. Never.
that
I
they
got my
used for all
phone.
3 buys, the cell phone that they recovered from him.
Never took my phone.
Did they ever take?
I don't
There's
know.
nothing to
No.
forfeit
No,
then.
right, right. I
What
got
about
my
money?
phone.
Let's try 3 for 3.
Yeah,
All right, so you'll be forfeiting that at the time, you understand that?
yes, sir.
All right.
I never took my
So they can't forfeit.
phone. Right.
All good?
Yes, Your Honor.
All right, Mr. Askew, now, so, a few moments ago, I explained the possible prison sentence you face. I did use the word possible, however, prison is not mandatory with these charges. You are eligible for probation, or what we formally call community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're asking for. I'll look at all the information that gets presented, then I'll make the decision that I ultimately think is the right thing to do. Do you understand that?
Yes, sir.
Now, if you are put on community control sanctions, it could be for up to 5 years. And as the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve a term in our Lake County Jail of up to 6 months as a condition of probation. So even if you were to get probation, you could still get local incarceration. That's not mandatory either, but it could be ordered up to 6 months in the county jail. Do you understand that?
Yes, sir.
And if you are put on probation at any point and you ever violate any of the conditions of your probation, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it was not initially 5 years. I could impose more restrictive sanctions against you, which could include an order that you serve time in our county jail. Or I could at that point terminate or end your probation and send you to prison then. And again, that could be ultimately up to a maximum of 5.5 years. Do you understand that?
Yes, sir.
Lastly, when we do come back here for sentencing, you're going to have the right on that day to say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. He's allowed to recommend a sentence to the court. The prosecutor is also allowed to recommend a sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever the lawyers say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to follow that if I didn't think that's the right thing to do. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all then regarding the potential penalties you face by pleading guilty?
Yes, sir.
You understand everything that could possibly happen at sentencing?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to talk about the case with your lawyer and have him go over the reports with you, discuss whatever issues there may be, and they answer any questions you may have?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes, sir.
All right, then do you have any questions for me at this time regarding anything we've talked about, the penalties you face, what you're pleading guilty to, the rights you're giving up? Any questions at all?
No, sir.
Do you need any more time to talk with your lawyer before we go forward with the actual plea of guilty?
No, sir.
Okay. So what's going to happen at this point is that the prosecutor here is going to explain for me what he believes the evidence would show if we had a trial. I want you to listen to him because I have some questions for you about that, all right? So, Mr. Geigerich?
Thank you, Your Honor. The evidence would show that the defendant was targeted by Lake County Narcotics with a confidential informant. On November 25th, 2024, a deal was set between the CI and the defendant for $50 for crack cocaine. The deal was to occur at 313 7th Street in Fairport Harbor, Lake County, Ohio, which was the defendant's residence. The deal did in fact occur. The suspected narcotics were sent to Lake County Crime Lab where it tested positive for cocaine, an amount of 0.47 grams. After 2 other controlled buys at the residence, a search warrant was executed at the 313 7th Street Fairport Harbor residence on December 20th, 2024. Off the defendant's person, they recovered a cell phone that was used for all 3 buys, $104 in U.S. currency in his right pocket, and suspected powder cocaine in his right jacket pocket. And inside the residence, they found a pill bottle with 2 baggies with white powder in the dresser bedroom 1, a baggie with white powder in the nightstand, $770 in U.S. currency in the dresser bedroom 1, a Beretta 9mm pistol, A High Point pistol and a Smith & Wesson .38 revolver were recovered from the living room dressers and the bedroom dresser. And a jar with suspected lidocaine was in bedroom 2 in a box. The defendant stated he knew the firearms were in the house and he admits he deals with people he uses with. He is correct. They gave the phone back to the defendant after his contacts were photographed because he claimed it was his work phone. The defendant had previously been convicted of possession of cocaine in Lake County Common Pleas Court of 08 CR 661 for possession of cocaine. He was convicted on October 20th, 2009, which would prohibit him from having a firearm. Thank you, Your Honor.
Man, so let's make sure we're on the same page that they returned the phone, so it's not being part of the voluntary
No, it
forfeiture.
is not.
Okay.
And the cocaine that they recovered from the residence was 8.49 grams after being sent to the Lake County Crime Lab. Thank you.
Mr. Askew, were you able to hear what the prosecutor just had to say regarding what he believes the facts would show if we had a trial?
Yes, sir.
And what, if anything, do you have to say about those facts as he presented them regarding those 3 counts? Are they true? Did you do what he said?
Yes.
Very well, then, regarding count 1, charging with trafficking cocaine and felony the 5th degree, what is your plea at this time?
Guilty.
Regarding count 4, we're charging with possession of cocaine and felony the 4th degree, what is your plea to that count?
Guilty.
And regarding count 5, charging with having weapons while under disability, a felony the 3rd degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time a 4-page document. It's called a written plea of guilty and judgment entry, which explains everything we've just gone over. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over this with your lawyer. Is that correct?
Yes.
Mr. Kuharski, is that accurate? Did you read this over with Mr. Askew, review it with him, answer any questions he has?
I have, Your Honor, yes.
In doing so, did he indicate an understanding of it to you?
He did.
Is that correct, Mr. Askew?
Yes, sir.
So you understand what this document says?
Yes, sir.
You have any questions for me about it?
No, sir.
It also appears on the last page, at the top of that last page, you signed the document. Did you in fact sign it?
Yes.
Mr. Kuharski, excuse me, you witnessed that?
I did.
Mr. Geiger, you as well?
I did, Your Honor.
Very well then, at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, trafficking cocaine, a felony of the 5th degree, violation of 2925.03A1. Count 4, possession of cocaine, a felony of the 4th degree, in violation of 2925.11. And count 5, having weapons while under disability, a felony of the 3rd degree, in violation of 2923.13A3. The remaining counts will all get dismissed. I'll defer sentencing, order a pre-sentence report and investigation. Are you requesting any other evaluations? Did you want a drug and alcohol evaluation, or is that
Yes, Your Honor.
a drug and alcohol evaluation? And I will continue your bond. That is at $7,500 cash surety or 10%. So what all this means, Mr. Askew, as far as bond goes, I'm continuing the bond that's been posted. Nothing more you need to do at this point. You need to follow the conditions of your bond, which have been in place since the beginning here. One of those is that you don't use any drugs while you're on bond. You have to submit urine screens if requested. Those must be negative. A positive screen will result in your bond being revoked and a warrant being issued for your arrest. Now, the purpose of these reports is so that I can learn more about you before sentencing. And the way the probation department will go about getting that information is they're going to conduct some interviews with you. It's important, first of all, that you show up when you're supposed to for those interviews, because they can't conduct the interview because you didn't cooperate or you didn't show up, then they can't complete a report. And without a report, the law doesn't even allow me to consider probation as an option. You understand that?
Yes, sir.
It's also important that you be open and honest with them, because they're going to check and verify everything you tell them. If they learn you're misleading them in any way, they'll let me know that, and I would consider that at sentencing. Do you understand that?
Yes, sir.
All right, so you're going to leave here now. You're going to go over to the probation department. fill out some initial paperwork and get the dates to come back for those appointments. So make sure you do that when you leave here, all right?
Yes, sir.
Mr. Gagich?
Your Honor, you're dismissing the charges now?
I thought I said I'm deferring, I said sentencing, but I'm deferring sentencing.
You're right, and then you said the remaining charges are dismissed. That's why I was curious.
I thought I said they'd be dismissed at sentencing, but
Okay.
sentencing is deferred. No, it'll be dismissed at sentencing.
All right.
Mr. Kowarski, anything else?
Nothing further, Your Honor. Thank you.
All rise. This is case number 16 CR 000426. In this matter, the defendant has filed a petition application for sealing a record, and the state has responded to that. So we are here today for purposes of the hearing. At the time of the filing of the state's response, the defendant, it had been about 8.5 years, and the defendant had not paid all of the amount that was due. In speaking to probation, my understanding is that she has, in fact, paid that amount at this point in time. The state just noted that she does have that history of criminal convictions and that there has not been anything provided or was not anything provided showing that she had been rehabilitated to a satisfactory degree. If the court makes that determination, then the defendant is eligible and we would not object to the court granting that.
What do you look for in that regard? What does she need to provide to show that she's been rehabilitated?
Just a law-abiding life, that she hasn't been using drugs or alcohol, and at least at this point in time that there aren't any criminal charges pending. According to the review of the record, it does not appear that anything additional is happening except for the OVI following this particular case.
Mr. Graziani, would like to be heard on your request?
Yes, Your Honor. Tammy has been out of trouble for the last 9 years. Going to jail was the best thing that ever happened to her, in her own words. She learned to swear off the drugs. She's been clean for that long. She's a business owner, and now she's being plagued by this lone felony conviction from 20.
Now she's being what?
She's being plagued by this lone felony conviction.
What do you mean plagued?
Well, she cleans businesses and people's homes, and when they do background checks on her, she shows up as a convicted felon. And so enough time has gone by. She's eligible for expungement. All of her fines and costs and everything else have been paid. She hasn't been in trouble. She does have a couple older cases prior to this one in other places, but nothing since 2015.
Well, she's got an OVI.
Yes, but even that's old. I mean, it's not as old as this case. But any other prior criminal convictions were prior to this case. And
I
so,
guess I just don't understand what you meant by she's being played by the...
yes, because she has a business, and she contracts with people and businesses to clean for them, and all they have to do is look up her record, and she shows up as a felon.
Okay.
And so to remove that, to enhance her business, to allow her to prosper in her business, then we want to remove this from the public's.
I get it. I guess I've just never heard that term, being played by...
Yes.
I mean, all right. I envision that term as someone's like using that against her to contact competitors to say you don't want to hire her because this is happening. That's how I was envisioning.
Well, in today's world with the internet and everything, it's too easy to find people's backgrounds.
Well, she's not being played by it, but anyway, all right. Okay. I mean, it's there. It's part of her history, but so it's something she would have to deal with unless it's gone. Pronounce your last name for me? Trecarici. Sorry about that. So what have you been doing since this case got concluded?
I own a cleaning business.
Where is
do
that?
About Medina County.
Okay.
That's where I'm from, Litchfield.
Is that where you were when this was going on, or? Do you remember?
Sometimes.
Okay.
Yeah. And we probably do about 80 to 100 cleanings a month. My daughter is 20 and goes to CSU, so I employ a lot of the college kids that work for me. It's really emotional to be here
Take
today.
your time.
It's full circle, regardless what the result is. I put the work in, and like he said, I tell everybody the 6 months I did in prison was a blessing. It probably saved my life.
Did you go to prison, or did you go to...
I went to prison.
Oh, because you violated your probation.
Right. And I needed to. That was exactly what I needed. I didn't know it then, but my mom died of cancer. 9 days later, my husband shot himself in front of me. And I just didn't heal, and I just kept self-medicating. So them 6 months to sit there clean and process all that, I came out a different person. And I wasn't even the person before, because you never are again. But I came out solid on the other side. I'm thankful for that journey. And even the DUI was like
And what's that all about?
You can't drink either. Like,
That was alcohol?
yeah, yes.
What were the circumstances around that?
I went out with some friends after work,
You
made a
drank too
bad
much?
choice.
You drink anymore?
I
little
do,
bit.
casually, couple drinks, nothing. I don't drink and drive. I haven't done drugs since I came home from prison. I think it was cleaning my mind, you know, like, I'm a healthier person. I don't do AA or NA, but I just, it's my willpower.
When did you start the company?
It's 2 years this month,
Okay.
yeah.
It's pretty successful, doing well?
Yes. And I wouldn't say plague. I would say sometimes I don't get jobs that I would like, but I'm going to be successful regardless. I would love to have it just so I can close that chapter. That would be amazing, but I think I have peace either way. Like, it's not going to hinder what I'm going to do in life. I can't let it.
Well, even if I grant it, as your lawyer said, with the internet these days,
Yeah.
things can still be. It's just a piece of paper that's
Yeah.
going to say, but it doesn't eliminate the World Wide Web.
And I'm open-
But it allows you to say you don't have the
It
conviction.
opens more
It
doors.
allows you to not have to report it when you sign things or
Right.
request things or do all that, and you're doing that, and that's legal the way you're doing it. Then you're not lying about it or falsifying
not at
anything
all.
when you do it. I just don't want you to be under that. You know, if someone still finds out about it, they're not doing anything improper by it, but you're not doing anything improper by saying you don't have it.
Right. I don't ever lie. I'm very transparent.
Is there anything else you'd like me to know?
I'm a pillar in my community. I do a lot of give back from feeding Medina County.
Let's say you turn that off.
Thought I did turn it off.
Go ahead.
We do a lot of fundraisers for Medina County. We raise money for feeding Medina County. We also do like where we adopt families for Christmas, and we raise the money in various ways, like wing night or whatever it is. And the group that I'm a part of, it's a networking group, but it's a nonprofit. Over the last 10 years, they've raised over $30,000 for feeding Medina County, and I love that part. Like, if we only feed our wallets, we're not feeding our souls. So I love to be able to give back from a community because I feel like I've took from a lot of communities.
Where are you from? Are you from this area or from down there?
Medina.
You're from down there? All right, well, thank you. Mr. Graziani, anything else you'd like to
No, Your Honor.
state? What's the state's position? You may have stated it, but
Your Honor, in
Oh, you
light
did
of what
state
she's stated, we don't have any objection.
Ms. Crook,
Yes,
everything's been paid up?
yes, yeah, since the report was completed, everything has been paid for.
All right, well, I've considered the motion that was filed, the report that was prepared by our probation department, what's been said here in court. At this time, I find the defendant is eligible to have this conviction. What was requested here? Defendant is eligible to have this conviction sealed, and I find the motion well taken, and I will grant that motion. So we'll prepare an entry granting your request. It should be prepared in the next few days. A copy will be sent to your lawyer. We can send a copy to you as well. Is that the correct? I have Litchfield, Ohio?
Yes.
Okay. 4780
Bryanton.
Okay. We'll send a copy there as well.
Thank you so much.
You are welcome. I'm glad, this is a nice part of what we get to do. We don't get to do this too often, so I'm glad things have turned around for you and you're doing well. Hopefully you can continue with the success you're enjoying. So good luck.
Okay.
Anything else for the record?
No, Your Honor, thank you.
Mr. Graziani?
No.
All right, thank you.
All rise. We are here in the case of State of Ohio versus Willie Crenshaw, the third, case number 25 CR 311. Defendant is present, represented by defense counsel. We're here for a change of plea hearing. State's offer in this case is count 2, carrying a concealed weapon, felony of the 4th degree. The state has not committed to any sentencing recommendation at this time as a part of this offer. It's my understanding the defendant wishes to accept the offer.
Thank you. Mr. Hinton, is all that accurate?
That is, Your Honor.
And Mr. Crenshaw, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this morning?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty to count 2 and plead guilty to that charge. Counts 1 and 3 would get dismissed. We would defer sentencing, get some reports completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties that you face. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you any of these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
Okay. All right, let's get started then. How old are you, sir?
18.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yeah.
Sorry?
Yes, Your Honor.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No, Your Honor.
Not even prescribed medication? Nothing?
No.
Okay. Now, you should have received a copy of the indictment in this case. Well, hang on one second. Hang on one second. Yeah, you should have received a copy of this indictment probably around the middle to end of April. Do you remember getting that? That's the document that says what the charges are?
Yeah, Your Honor.
And did you have a chance at some point to look that over?
Yeah, Your Honor.
Now, in that indictment, you are charged with 3 counts. You're only pleading to one of them. And that's count 2. And in count 2, what's alleged here is on or about March 7th, 2025, as a part of a course of criminal conduct in Cuyahoga County and Lake County, Ohio, that you didn't knowingly carry or have concealed on your person, ready at hand, a handgun other than a dangerous ordinance, that being a Glock 20 pistol. It's further alleged the weapon involved was a firearm that was loaded or for which you had ammunition ready at hand. That conduct constitutes the offense of carrying concealed weapons. It is a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in count 2 here?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, the charge also carries what we'd call a forfeiture specification, which alleges during the commission of the offense, you had in your possession this Glock 20 pistol, which was used as an instrumentality, which means it's property that was used to commit or facilitate the commission of an offense. And the whole point of this is that you forfeit any right you have, ownership right you have to that firearm. You understand that? It doesn't increase any potential penalty you face or anything like that, but you just forfeit any interest or ownership interest you have. You understand that?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Now, there are 2 other counts of the indictment. Those are being dismissed pursuant to the agreement. Is that your understanding?
Yes, Your Honor.
Do you have any questions about any of those 2 charges?
No, Your Honor.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to have a trial. Now, a trial could be to me as a judge, or I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would then consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together one way or the other, as to each separate charge, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation, she bears the burden to prove you guilty at a trial before you could ever be found guilty. You're presumed innocent of this charge, and that presumption of innocence stays with you throughout all the proceedings until the state, if at all, is ever able to overcome that presumption and prove you guilty at a trial. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since it is a criminal case, the burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of this charge beyond any reasonable doubt before you could ever be found guilty of this charge. Do you understand that?
Yes, Your Honor.
Do you understand that by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least to try to do that if we had a trial, the prosecutor would bring witnesses to come into court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. He could ask him anything he wanted to, within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty or giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right, if we went to trial, you could call your own witnesses to come to court to testify for you if you wanted, though you're not obligated to do that. That's a decision that you'd have to make for yourself. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court to testify for you and answer your lawyer's questions if there was someone that wasn't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you alone would have to make. Do you understand that?
Yes, Your Honor.
And since that's ultimately your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you did not want to. I can't make you testify. But more importantly, the prosecutor is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you don't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty today, you're giving up or waiving any right you have to appeal any guilty finding that I will make if I accept your guilty plea, as well as any other issues that you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all regarding these rights we've just discussed, these are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
You understand a guilty plea is a complete admission of guilt. That means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 4th degree. This is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, Your Honor.
You're currently on probation or parole to any of the courts or agencies?
No, Your Honor.
Give me 1 second, please. All right, sorry about that. Do you have any other charges pending against you anywhere right now?
No, Your Honor.
Now, if you are sent to prison, upon your release from prison, you could be placed on what we call post-release control. It's sometimes called parole. That's a period of supervision you would be on after you served the prison sentence, and it could be for up to 2 years. You understand that?
Yes, Your Honor.
And if you are on post-release control and you're violating any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term is imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. You could be fined up to $5,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison sentence you face. I did use the word possible because prison is not mandatory with these charges. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're asking for. I'm going to look at all the information that gets presented to the court. Then I'll make the decision that ultimately I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on community control, it could be for up to 5 years of supervision. And as the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions can be in order that you serve a term in our Lake County Jail of up to 6 months as a condition of your probation. Do you understand that?
Yes, Your Honor.
Further, if you are put on probation and you ever violate any of the conditions of your supervision, we will have a hearing here in court to see if you're what's called a probation violator. If it's determined that you are, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, again, it could be 6 to 18 months in prison, and that could be consecutive to any other prison sentence that you may be serving for something else, or that you're being sentenced to at that time for something else. Do you understand that?
Yes, Your Honor.
Lastly, when we do proceed to sentencing, you're going to have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. He could recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right. Well, do you have any questions at all regarding the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yeah.
Do you
Yes,
still
Your Honor.
do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk about this case with your lawyer? Have him go over the reports with you, discuss whatever issues there are, answer your questions?
Yes, Your Honor.
Are you satisfied with his advice and counsel
Yes, Your Honor.
of your lawyer?
Yes, Your Honor.
Has he or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering this guilty plea freely and voluntarily?
Yes, Your Honor.
All right. Do you have any questions then for me at this time regarding anything we've just talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to?
No, Your Honor.
Do you need any more time to talk to your lawyer before we go forward with your plea?
No, Your Honor.
All right, then what's going to happen now is that the prosecutor here is going to explain for me what the facts would show regarding this count 2. I want you to listen to her and what she says, because I'll have some questions for you about that, all right?
Yes, Your Honor.
All right, Mrs. Gretzky?
The evidence would show that on March 7th, 2025, in Willoughby Hills, Lake County, Ohio, Willoughby Hills officers started to follow a vehicle for traffic violations and was also waiting for confirmation as to warrant status for a registered owner of the vehicle. Proceeded to follow the vehicle into Cuyahoga County and then initiated a traffic stop by turning on the lights and sirens to the police cruiser. The driver of the vehicle did not comply with those orders and continued to drive and exit onto Wilson Mills Road. The defendant was not the driver, he was in the back seat. The driver, however, made multiple traffic violations and ultimately disabled his vehicle in the Golden Gate Plaza off of Mayfield Road. The defendant, along with the driver, then ran to the back of the plaza and jumped the fence and was eventually apprehended with the assistance of Mayfield Heights Police and Highland Heights Police. Officers searched the vehicle, and in the back seat where the defendant was seated, a Glock 20 was found between clothes and partially in a book bag. There was 1 round in the chamber and 12 rounds in the magazine. The defendant was 18 years old at the time. The defendant admitted to handling the gun when interviewed back at the Willoughby Hills Police Station.
Mr. Crenshaw, were you able to hear what the prosecutor had to say regarding what he believes the facts would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts? Are they true? Did you do what he said?
Yes, it was true, Your Honor.
Why'd you have the gun?
No, for protection, because it's a lot that going on out here. The gun was not intended
Is that your mother?
No, that's my grandma.
Well, look at your grandma right now. You should have seen her face when the prosecutor said those facts, that you had this gun. How does that make you feel?
Bad.
So those facts are true?
Yes, Your Honor.
Very well. Regarding count 2, charging with carrying a concealed weapon, a felony of the 4th degree, what is your plea?
Guilty.
Hope you remember this. I have in my possession right now a document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document, that you sign it here in court. My understanding is before I came out here, you had a chance to go over this document with your lawyer, is that correct?
Yes, Your Honor.
Mr. Hinton, is that accurate?
Yes, Your Honor.
You reviewed this and read it over with your client?
Yes, Your Honor, he read it, and I went over any questions that he had regarding it.
Did he indicate an understanding of it to you?
He did, and he had it ahead of time as well. I sent him an electronic copy a few days ago.
Is that correct, Mr. Crenshaw?
Yes, Your Honor.
You understand what this document says?
Yes, Your Honor.
Any questions for me about what it says?
No, Your Honor.
Did you sign the document?
Yes, Your Honor.
Mr. Hinton, you witnessed that?
Yes.
Yes.
Mr. Gretzky, you as well?
Yes, Your Honor.
Very well, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect, defendant was here in open court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 2, carrying concealed weapon, felony of the 4th degree in violation of 2923.12A2. Along with the forfeiture specification. The remaining counts will get dismissed at sentencing. I'm going to the first sentencing, order pre-sentence report and investigation. Any other reports you're recommending or requesting?
No, Your Honor.
You have any issues with any drugs or marijuana?
No, Your Honor.
You're not going to test positive for marijuana?
No, Your Honor.
All right. So pre-sentence report and investigation. Continued bond of $20,000 cash surety with the condition that the defendant not drive. So what all this means, Mr. Crenshaw, as far as bond goes, I've continued your bond. There's nothing more you need to do at this point regarding that except to continue complying with the conditions of your bond. Again, one of those is that you don't use any drugs, which includes marijuana. If you do, you have to submit urine screens. If they come back positive, your bond would be revoked and a warrant would be issued for your arrest. You understand that?
Yes, Your Honor.
Purpose of this report I've ordered is so I can learn more about you before sentencing, and the way the probation department gets the information they need is they'll conduct an interview with you. It's important that you show up when you're supposed to, on time, and that you're open and honest with them, because they're going to check and verify everything you tell them. If they learn you're misleading them in any way, they're going to let me know, and I'll consider that at sentencing. You understand that?
Yes, Your Honor.
You also need to make sure that you do show up when you're supposed to, because if you don't show up for that interview, and that means they can't conduct the interview with you. If they can't do an interview, they can't do a report. And without a report, the law doesn't even allow me to consider probation as an option. And I won't continue the sentencing to another day to get the interview done because it wasn't completed initially because you didn't show up when you were supposed to. Do you understand that?
Yes, Your Honor.
All right, so you're going to leave here right now. You're going to go to the probation department. Your lawyer will show you or tell you where that is. You're going to meet with them, fill out some initial paperwork, and get your date to come back for that interview. So make sure you do that right when you leave here, okay?
Yes, Your Honor.
All right, Mr. Hinton, anything else?
Nothing further, Your Honor.
Mr. Gretzky?
No, Your Honor, thank you.
Thank you. Mr. Gugich?
Thank you, Your Honor. Before, you good? I'm sorry. State of Ohio versus Katie Erie, file 25 CR 171. We're here today for sentencing. State of Ohio has had the opportunity to review the pre-sentence report and is prepared to go forward. Thank you.
Ms. Khan, is there any reason not to go forward with sentencing?
No, Your Honor, we're prepared to go forward.
Is there anything you'd like to say on behalf of your client?
Yes, thank you, Your Honor. We'd like to ask the court today to allow Ms. Erie to be put on community control sanctions and do some sort of drug treatment. And speaking with Ms. Erie, she's indicated to me, she is an addict. She does have issues with drugs. She knows she needs help. She knows she needs assistance. She has been in contact with Signature Health. It was a little bit of touch and go with them for a little bit because of her insurance running out. She's finally got that all sorted out. She is working under a hardship with them for another year. She did owe money to them, but that's all been sorted out. So she's working with a dual diagnosis counselor. Her name is Jacqueline. Her and I have been trying to get in contact with each other, but unfortunately our schedules have not lined up. I've been trying to get that documentation regarding Ms. Erie. But she indicated to me she is starting her IOP at 4 o'clock today. That's going to be about 4 days a week. In speaking with Ms. Erie, she knows she needs help. Her biggest concern right now, though, on top of getting help with her addiction is her job. She's been in her job for a little over 3 years. She works at Panini. She says the longest she's ever been at a job. She makes good money there, so she is concerned about losing her job. However, she knows her sobriety is the most important thing, so she is willing to do any sort of treatment that the court would order. She's willing to do any treatment on her own as well. I did touch base with her regarding residential treatment or some sort of inpatient treatment. I told her there's many different programs that she could do. She said she'd be interested in looking into them and doing them and see what options there are. She is going to work with her boss and speak with her boss to ensure that she can keep her job on top of doing treatment and getting all this resolved. She is looking into doing the driver intervention program. She is on a waiting list out of Willoughby, and then she was looking at somewhere downtown to do. So she's trying to be as proactive as possible. I know she does have prior prison on her record, Your Honor. I do believe the 2019 case was mandatory prison. And just to be transparent, Judge, I know in the police report and based on talking to Ms. Erie, she did use when she got released from prison, so I don't...
She what?
She did use when she got released from prison. So I think if we gave her an opportunity to get her sobriety under control...
That was 3 years ago.
Yes. Yep, so I think with treatment, Ms. Erie's fairly confident in herself that she'll be able to stay on the path of sobriety. Thank you.
Mr. Erie, you have the right to address this court before you're sentenced. You can say anything you want. Is there anything you want to say?
Yes, Your Honor. I don't know. I know I'm too old for this, for sure.
Yeah, but you keep doing it.
I know. It's recovery is just, mistakes. But the times here I wasn't using. I was about to use, about to go sell, be honest with you, and I got caught. So obviously something's keeping me from going down that path, which is...
Yeah, the police pulling you over, or whatever it was.
To say what?
The police pulled you over.
Yes. Well,
Wasn't that you made this
me and an old
conscious
man,
decision not to do it?
me and an old man collided, kind of skid cars, and that was the reason. So,
But it was other person. All right, go ahead.
right. So it was my fault. I shouldn't have the drugs in the first place. But I'm willing to do the inpatient treatment or residential or whatever. But I'm house sitting for my uncle right now, so I still got his trust after all this time, and my mom, and I want to do the right thing. I want to get sober, which I have been. I just went off
You
path.
picked up a new offense while you were on, or at least arrested for a new felony charge just a couple days after you pled guilty here.
That I didn't know was coming out. They sent it to the lab. I didn't know it was right then and there. I didn't know that, or I would have told you.
That didn't happen until just a couple days after. Am I wrong about that?
No, yeah. Since I seen you, this was.
Yeah, that incident occurred 3 days after you were here.
I think it came out.
Or no,
of the
I'm
lab.
sorry, you're right. No,
Yeah.
no. It happened in April while you were on bond in this case, though. It happened in April.
Yeah.
The incident itself.
And it was none of mine. I mean, I should have I went off path with my insurance. I stopped talking to my counselor, IOP, stopped going to my AA meetings, and this is what happened. So now I'm trying to get back on the right path. And I am. I'm doing it.
You're doing what?
My proactive in sobriety. I'm back in my AA meetings. I'm going to IOP. I'm talking to my counselor.
You're not going to IOP.
Today at 4. I just got in.
Yeah, and
It was hard to get into.
anything else you want to say?
No, sir. Thank you.
So how long you been using for? Since you got out of prison?
That one time, and that was
Then
it.
why'd you tell the police something different when you got arrested? So the day this happened, well, when you met with your probation officer, you told the probation officer you relapsed in November on methamphetamine. You told the police on the night that this happened that you started with meth the day you got out of prison and you were released on parole.
No.
That you injected in your varicose vein on your right leg, that you take the pills that were found were gabapentin, you take one prior to and one after injecting your meth, that you go to the streets to get your meth and your gabapentin. You pay $1 per pill and $40 for the meth.
That's what it says.
Yeah, that's what you told us. The police
I
report
did not
says. That's
say
what.
any of that to the police.
And they made all that up.
I mean, I'm not saying
And
they probably
made
just
up-
mixed my words up, but I was not using. I'm not using. I was about to use, yes. Because I got off path. But I was about to.
Anything else you want to say?
No, sir.
Ms. Tomazik, anything?
Nothing further, Your Honor.
Mr. Gagrich?
Thank you, Your Honor. The state of Ohio believes that community control, while isn't indicated in this case, but would be appropriate, and to try to get her back to being a normal person. But we would ask you to accept the joint recommended community control sanction. Thank you.
This court reviewed the pre-sentence report and investigation, drug and alcohol evaluation. Have considered the facts and circumstances of the offense involved, the nature of the offense. Consider what's been said here today by everyone. All this is considered in light of the purposes and principles of felony sentencing, which are set forth in 2911. For the factors in 2912, factors indicating the conduct is more serious. The court notes the defendant was operating a vehicle at the time she committed the possession charge, which makes that more serious. Nothing makes it less serious. As for recidivism factors, court finds the defendant was on post-release control at the time she committed this offense. She has a history of criminal convictions. She's not responded favorably in the past to previously imposed sanctions. She's been on probation before to this court, quite frankly, and has violated her probation. Oh wait, let me make sure that. Could be getting confused with Cuyahoga. That was Cuyahoga. She was on probation for and violated her probation after this court. She was on probation at Cuyahoga and violated that. There's a drug abuse problem that relates to the offense, and she doesn't acknowledge the seriousness of this problem and the issues that she has. No genuine remorse in regards to this offense. I read your statement regarding this offense. You blame everybody. You blame the person that you were with at the time for not manning up and taking responsibility for the charge. He put me in situations no man should put his women. He didn't man up for this. You got in a car accident, which was the other driver's fault. You got treated by the police unfairly. You should not have been charged with an OVI. They lied in the police report. They acted inappropriately during your arrest. But you pled to this because you didn't want to, quote, take anything to the box. So that, to me, that means you don't think you're guilty, but you're just taking this because you don't want to go to trial, risk going to trial. So it's everybody's fault but yours. And you didn't even do this. It's the guy's fault. Whoever this man you were in a relationship with for 11 years, he didn't man up and take responsibility for this, so you had to do it. So that happens in January. And in April, pick up another charge. Charge comes down in June, but it was for an incident that occurred in April while you were on bond to this court. I don't see how, and you're on parole this whole time. I don't see how you're making an effort to get better. You pick up 2 felony charges while you're on post-release control. Second one while you're on bond on another felony charge, and you're just continuing to engage in the same conduct. So there are all factors indicating recidivism is more likely. There's no factors indicating it's less likely. Under 2913B1, court finds defendant has previously served a prison term that overrides any presumption for probation, allows the court to impose a prison sentence without having to make any special findings. With the history here, prison is certainly consistent with the purposes and principles of sentencing. Defendant gets out of a 3-year prison sentence, she's on post-release control, and she picks up new felony drug charges. That's certainly consistent with prison. But I'll give you one chance, Ms. Yuri. I'm very, very leery of this because I think you're a lot of talk here. But I'll give you one chance to live up to what you're saying. If you prove me wrong, I'd be very happy to be proven wrong. I think this is going to be not work out, to be honest with you. But I'll give you the chance, and I'm rooting for you. Prove me wrong. I'll be happy for that. But you need more help than just an IOP. I'm going to put you on community control sanctions on count 1, on both counts, for a period of 2 years. I'm going to order that you serve 62 days in jail. You have credit for 2 days served. I'm going to order that you enter and successfully complete the jail treatment program, follow all their aftercare recommendations. On completion of that, you are to enter and successfully complete the residential treatment program at either Nevaeh Ridge or Oak House, whichever has a bed available first. As soon as the bed's available after completing jail treatment, you can be released from the jail to enter whichever facility, again, has that bed available. Any balance of time, if there is any, will be vacated. You successfully complete that treatment program, follow all aftercare recommendations. Further conditions, you are not to use any drugs or alcohol. You must submit random urine screens. Those have to be negative. Positive screen will be a violation. You're to attend 3 AA meetings a week and have a sponsor. To maintain full-time employment once you get done with the treatment. You'd have 1 doctor and 1 dentist that could prescribe you medication, 1 pharmacy where you get them filled. Probation needs to know who those doctors are and where the pharmacy is. You got a specialist, that's fine too. But they need to know who the doctors are that are giving you prescriptions, and only have 1 pharmacy where you get them filled. You can sign a release so that they can contact these doctors if deemed necessary. I want you to get a mental health evaluation and follow any recommendations for any type of counseling. Take any and all medications as prescribed. Pay court costs and supervision fees. As for the OVI offense, well, the 60 days is on both counts concurrent.
60 days on both, okay.
But there's a mandatory fine I must impose. I'll impose the minimum mandatory fine, $565. Suspend the defendant's driver's license for the minimum, 1 year on count 2 and 1 year on count 1. Those will be concurrent suspensions. They're both mandatory suspensions. Jennifer, any other conditions or?
Your Honor, the driver's license suspension should start on today's date or the date of the offense.
Well, it starts on today's date,
Today's date.
unless there's an ALS. There's not, though, my understanding is. Then it starts
Thank you.
today. Ms. Thomas, any, I'll strike that. Ms. Yuri, you understand all the conditions of your community control sanctions?
Yes, sir.
Any questions for me?
No, sir.
All right, I need to advise you that if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, it'd be 12 months in prison on count 1. And that would be consecutive to any other prison sentence that you could be serving at that time, or that you may be getting sentenced to for any other case at that time. So I'm giving you a chance here, but you need to take advantage of this and take it serious, put the effort in to get back on track here, if that's what you really want. And we'll find that out. We'll find that out. Ms. Thomas, is there anything else for the record?
Not this time, Your Honor. Thank you.
Mr. Bagridge?
Nothing, Your Honor, thank you.
Thank you, Your Honor. We are present in State of Ohio versus Roxanne Badker on case number 25 CR 513. We are here today for purposes of sentencing. We were last here on June 6th when the defendant pled guilty to count 1, illegal use of a minor or impaired person in a nudity-oriented material or performance, a felony of the 5th degree, and count 3, disseminating matter harmful to juveniles, a felony of the 5th degree as well. The court referred the defendant for a pre-sentence report and psychological evaluation and victim impact statement. Those reports have been completed and the state's prepared to proceed with sentencing.
Thank you. All right, before we proceed with the sentencing hearing, I am required to advise Ms. Badker of what her obligations and duties will be to register as a sex offender upon any release from any incarceration. So I'm going to do that at this time. So Ms. Badker, I'm required to read to you this form here, which you're going to get a copy of, so I'm not expecting you to memorize what I'm telling you, but it's going to outline for you all your requirements. When I'm completed reading it to you, I will ask you to sign the document. Your signature is simply acknowledging that I read it to you and you understand it. It doesn't mean you agree with it necessarily, but it's just that you acknowledge I read it to you and you understand it. All right, so if you have any questions, make sure you ask at that time. Before I get into that, I want to verify some information. Middle initials M?
Yes, sir.
What does that stand for?
May.
M-A-Y?
M-A-E.
M-A-E, okay, sorry. And your expected residence address is 211 Maplewood Avenue in DeKalb, Illinois?
Yes, sir.
What's the zip code there?
60115.
60115. And your phone number 630-806-5491?
Yes, sir.
And social security number 325-785875?
Yes, sir.
All right, I will begin at this time. You have pled guilty to a sexually oriented offense as defined in revised code section 2950-01, and you are hereby classified as a tier 1 sex offender. You will be required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if you are temporarily domiciled for more than 3 days. You're also required to register in person with the sheriff of the county in which you establish a place of education, if that's applicable, immediately upon coming into that county. If you establish a place of education in another state, but maintain a residence or temporary domicile in your home state, you will be required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You're also required to register in person with the sheriff of the county in which you establish a place of employment if you've been employed for more than 3 days or for an aggregate or overall total of 14 days in any calendar year. If you establish a place of employment in another state but maintain your residence or temporary domicile in your home state, you will be required also to register in person with the sheriff or other appropriate official in that other state if you've been employed for more than 3 days or for an overall aggregate total of 14 days in a calendar year. Employment does include volunteer services. Now, you are required to provide to the sheriff any temporary lodging information, which includes address and length of stay if your absence will be for 7 days or more. After the date of your initial registration, you will be required to periodically verify your residence address, place of employment, and/or place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. If you change residence address, place of employment, or place of education, if any of that's applicable, you shall provide written notice of that change to the sheriff with whom you most recently registered and to the sheriff in the county in which you intend to reside or establish a place of employment and or place of education at least 20 days prior to any change and no later than 3 days after change of employment. If the residence address changes not to a fixed address, you shall include a detailed description of the place or places you intend to stay and no later than the end of the first business day immediately following the day you obtain a fixed address, you must register with the sheriff that fixed address. You are further advised in accordance with federal law that you must report any international travel to your registering authority no less than 21 days prior to travel. Failure to do so may subject you to criminal prosecution. You shall provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers registered to you or used by you to the sheriff with whom you most have recently registered. Now, since you will be a Tier 1 offender, you will be required to comply with all of the above described requirements for a period of 15 years with in-person verification annually, meaning once a year. Now, since your expected residence address, as stated above, is in DeKalb, Illinois, or that's DeKalb County, actually, right?
Yes, sir.
DeKalb County, you will register in person no later than 3 days after release from any incarceration with that county sheriff's office, which I believe is located at 700 West Lincoln Highway in DeKalb, Illinois. Now, your failure to register, your failure to verify your residence at the specified times, or your failure to provide any notice of change in residence address or other required information will result in further additional criminal prosecution. You understand that?
Yes, sir.
All right, do you have any questions for me regarding these responsibilities or requirements that you're going to be obligated to follow?
No, sir.
All right, then I'm going to hand you at this time, my bailiff will hand it to you, the form I just read to you. On line 11, it reads, I acknowledge that the above requirements have been explained to me and that I must abide by all the provisions of the Ohio Revised Code, Chapter 2950, which is the section of our revised code that sets forth what I just read to you. So I'm going to ask you to place your signature on line 11. It's already got the date in there, which is today's date, July 7th. But again, this is acknowledging that I read it to you and that you understand that you have to follow those, what I read to you. So Ms. Backer, you just signed the document that had just been handed back to me?
Yes, sir.
I am going to place my signature now on line 12, which reads that I specifically informed the offender of her duties as set forth above, and she indicated to me an understanding of those duties. Place my signature, and then we'll give this back to the bailiff. I'm going to ask that you make 1, 2, 3 copies of this, 4 copies of it, and then we'll get your copy before the end of the hearing.
Thank you, sir.
All right, with that matter having been addressed, Ms. Tomazik, is there any reason we should not proceed to sentencing?
Your Honor, we're prepared to proceed with sentencing.
Is there anything you want to say on behalf of your client?
Yes, thank you, Your Honor. We'd like to ask the court today to allow Ms. Backer a chance on community control sanctions. Speak with Ms. Backer, she has no criminal history. She doesn't even have a traffic offense. This is her first time ever being in trouble. Ms. Backer and I have had many, many conversations. It's clear to me that she, throughout this entire process, has been very scared. Based on my conversations initially, it took her some time to fully understand the severity of these charges. It took some time to build up rapport because, like I said, she's never been in this situation before. So it did take some time for her to build that rapport with me and be able to admit what happened and understand the severity of it. I think she is still having a little bit of a difficult time with it. Her entire support system is in Illinois, so if Your Honor would allow her community control, we would ask for it to be transferred to Illinois, to her hometown. In speaking with Ms. Backer, every time I've seen her or talked to her in the jail, she's been very, very upset. I think she has a much better understanding now of how severe her consequences can actually be. She knows she lost her job. Her main priority is to find a new job and get home to her kids, to be a support system for her kids. Her 14-year-old son, Ms. Backer is the only parental figure in his life. They She does live with her friend Rebecca and one of the other kids' fathers, but overall with the parent, Ms. Badker is the only parent for her 14-year-old. I've received letters from her family and some of her close friends. I did forward those to the court. They describe Ms. Badker as a person who's willing to help others as best she can and to advocate for others any chance she gets. They describe her as a loving mother and friend and willing to do anything for anybody. So we would just like to ask to allow Ms. Badker a chance on community control. She's fully, at least with me, she is fully aware how serious her conduct is. And like I said, I think she's just had a very difficult time with this because she's never been in this situation before, so she has a hard time building that rapport with others and admitting to what has happened here. Thank you.
Thank you. Ms. Backer, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
I'm sorry for what I did.
What'd you do?
I sent inappropriate photos to an underage child. I'm sorry for what I did. Am I allowed to address his mother?
Sorry?
Am I allowed to address his mother?
You can say whatever you want to say.
Kelly, I'm sorry. I can't. Take back anything. I apologize for the things that I did. All I can do is be a better person. I'm sorry. I know that doesn't change anything, but I apologize to you, and I'm not mad at you for what you did. I'm sorry. I would like to go home to my children. You hold my life in your hands. I'm petrified. I don't want to go to prison. I've never been in trouble. I will do whatever you ask me to do. You want me to do backflips in my backyard? I will do that. I don't care. Whatever you ask me to do, Mr. Culotta, I will do. Just give me a chance, please. I have a 6-year-old, an 8-year-old, and a 14-year-old.
A 14-year-old, right?
Yes, sir.
The same age as the boy involved here.
I know.
What if someone is doing what you did with this 14-year-old boy to your 14-year-old boy?
I'm sorry.
What if there was some 44-year-old woman who
I
was
know.
engaging in conduct that you engaged in with your 14-year-old boy?
I know, and I don't.
You know what?
I know what I did was wrong. They did a no contact order, and I put it behind me over a
There
year
shouldn't be a
ago.
need for a no contact order.
I understand that, sir.
You drove in from Chicago or Illinois, wherever DeKalb is, to meet with a 14-year-old boy. Now you deny all that. This is all because you were being a good mother and you were bringing your son to visit with this boy that he met online, and you're just being the good chaperone mother to watch over them.
I never said that, sir.
You didn't admit that the reason you came into town was so that your son can.
My son was friends with him.
And that's the reason you came into town.
Well, whatever reason did I have? I had no intention.
For you to maybe meet up with the 14-year-old boy?
No.
You didn't.
I saw him, obviously,
And
yes, sir.
you weren't alone together with him?
No, we were all together.
You didn't walk into the woods with him. This is all on video.
Okay.
You can say whatever you want to say. 'Cause
Okay.
You haven't been forthright or honest or open
I have.
since at all with the probation department. So I'm not going to sit here and argue with you or debate with you. Is there anything else you'd like to say?
No, sir.
Ms. Tomasic, anything else?
Nothing further, Your Honor. Thank you.
Ms. Celesti for the state?
Just one moment, Your Honor. Your Honor, prior to addressing the court, the victim's mother is here and would like to speak.
Okay, sure. I did receive your victim impact statement. I've read that, but you're certainly permitted and welcome to speak here in open court as well. So take your time and say what you'd like me to know.
Thank you, Your Honor. I just want to say that these past several months have been hell for my family. I see the defendant crying and saying, like, you know, how awful it is for her and how she just wants to go home. But it doesn't erase what my family has been through. It doesn't erase the mental impact on my son. He's gonna remember this probably the rest of his life. He's just now like starting to understand that this wasn't okay, like this wasn't real. This wasn't a real relationship. It makes me a little bit upset to hear her lie and say that the reason for her coming over 6 hours was not for her to see my son, because that was exactly the reason why she drove across state lines. As there was so much evidence that I viewed myself as well as the police and detectives between the text messages and the computer chats. She even stated that she knew what she was doing was wrong. She had said that she would go to prison, that she would lose her job, she'd lose her kids, she would be on the sex offender registry, and still the conversations kept going on and on between them about how they loved each other so much, and they were going to find a way to be together after all of this. And my son actually thought that like he was in love with her and that she was in love with him. I mean, he was just a 14-year-old boy. So I personally feel like I was violated. What you said as far as how would you feel if some 44-year-old person did this to your 14-year-old kid? Like, yes, exactly. Like, Ms. Badker is 5 years older than I am, and she's engaging in this with a child that's the same age as her child. Like, she has another child, well, an adult child that's older than my son. Like, I could never imagine trying to pursue a relationship with somebody younger than than one of my children. Like, there's just no way that anybody could know that it's not wrong, or to not know that it's wrong. So I hope that you do take into consideration, what the information that you've, reviewed, and again, it's just, I don't know if you're a parent, but if you are, like, it's just to try to put yourself in those shoes. If somebody tried to violate your child, or take advantage of them, like, how you would feel, so I just, thank
All right,
you.
thank you. Ms. Leshy for the State of Ohio.
Thank you, Your Honor. One thing that stood out to me when I read the pre-sentence report in this case is that the defendant claimed that she was trying to mentor the victim. I think she kind of used that word or phrase repeatedly, and this is not only absurd, but it's wholly inconsistent with the evidence in this case. It defies logic to think that a 43-year-old woman who exchanged sexually explicit messages, photographs, and videos with a 14-year-old boy was acting in any way in a mentoring capacity. And the fact that she said this, I think, demonstrates a fundamental lack of understanding and accountability on her part. In some of those messages, and again, these are going to be the defendant's words, not mine, but just some of the things that she was saying to the victim in this case is, you want me to tell you how amazing it's going to feel when I feel you deep inside me, moaning your name, telling you how good you feel. Later that same day, talk to me if you ever want head from me. Then there's a lengthy conversation at one point where the defendant talks about putting a ruler in her mouth to measure how much of the victim's penis she can fit in her mouth, and solicits a picture of his penis for comparison. There's a lot of discussion about love and marriage and what their life will look like in the future. This is not mentoring. There is no world in which that could be considered mentoring a child who is around the same age as her own kid. And then to make matters worse, she schemes up this plan to come here from Chicago to meet up with the victim. The plan was to lie to the victim's parents to say that the victim would be hanging out with her son, again, who's close in age to the victim's age. And she drives here with her own family, her own kids. She rents a hotel room, and she meets up with the victim. And to continue on with this charade, this scheme, she even met the victim's parents. She met her in the parking lot. She greeted her. She chatted her up in an effort to put the victim's mother at ease about leaving him alone at the park with supposedly what was to be her son. The defendant tried to say that in the pre-sentence report that this was a family thing. However, the surveillance video depicts a very different story. It's caught on video what exactly, where they go, who's where, when. And it's not even worth contesting that the victim and the defendant were alone in the woods for a period of time. And then you see him kiss on the surveillance video. And again, it just makes things worse that she had her own kids with her. In the messages exchanged between them, you even see conversation about plans to do this again in the future. Now, luckily, this was reported to the police and stopped before it could get to that point, but there was certainly plans to do that. And then, you know, it's upsetting to hear the defendant in her pre-sentence report really not understand the severity or the gravity of this, because even in messages with the victim, she knew it was wrong. She talks about the legal age of consent in the state of Ohio. She talks about the repercussions or consequences if she got caught, that she could potentially go to jail or prison. But then she did continue to talk to him. Around the same time she's exchanging those messages, showing how she knows this is wrong, she's sending more messages. You want to fuck my tight pussy with your big cock. Touch me. Violate me. Under 292913B1B, because she's been or pled to a sex offense here, she's not entitled to the presumption of community control sanctions. In the pre-sentence report, she maintains that she doesn't require any form of treatment or counseling. And even today here in court, by not acknowledging what her plan was when she came here, what she did with the victim in the woods, I think demonstrates that she has no insight into the predatory nature of her conduct, or even any remorse. So the state is recommending prison. Prison's appropriate here, not only to protect the public from future crime, but also to punish the defendant. Thank you.
Thank you. This court has reviewed and considered the pre-sentence report investigation, psychological evaluation. I received a victim impact statement. I've read and considered that. I received numerous letters in support of the defendant. I've read and considered all of those. I've also considered the facts and circumstances of the offenses involved, the nature of these offenses. I've considered everything that's been said here today in court by the defendant herself, her lawyer, the prosecutor, the victim impact statement made here in court. All of this is considered in light of the purposes and principles of felony sentencing set forth in 292911 of the revised code. I've also considered the factors under 292912, factors indicating the conduct is more or less serious. Factors indicating the conduct is more serious. It's the fact that the defendant, there's 30-year age difference between the two here. Many of these cases, most of these cases we see, there's not that big of a gap between the age of the adult and the age of the minor involved. That you used your own children to facilitate this offense and used them as a charade when you came and visited. 14-year-old child is the same age as the purported victim, not as the victim in this case. And you use them in these circumstances. Nothing indicates it's less serious. As for recidivism factors, there's absolutely no genuine remorse. You don't acknowledge doing really anything wrong except for sending a picture of your boo, I think is what you said. As the prosecutor alluded to, I'm not going to get into it much more, but you claim to be a mentor to him. I don't know if you think we're idiots up here, but I was able to read all your text messages that you sent, the videos that they showed. Did you? What am I supposed to just be ignoring all that?
No, sir.
You are. Is that what you consider mentoring? Sending the messages that the prosecutor just related to us? Because those are all messages that you wrote.
Yes, sir.
And that's what your definition of mentoring is. Mentoring a 14-year-old boy. You referred to this as a misunderstanding somewhere in one of the reports, I believe. Well, I don't know what we misunderstood. But there's absolutely no remorse, let alone genuine remorse. There's also significant issues here that you don't believe you need any help with or any treatment with. That you're just a caring adult that looks to help younger kids out. And this is your definition of helping them out, apparently. As for factors indicating recidivism is less likely, there's no prior convictions. You led a law-abiding life your entire life up until this. Under 2913B1, the court notes this is a sex offense, both of these charges, which overrides any presumption for community control and permits the court to impose a prison term. Prison certainly is consistent with the purposes and principles of sentencing, and there's no way the court can make a finding you're amenable to community control sanctions. You don't think you did anything wrong, except for sending a picture of your boob, and it went way beyond that. Therefore, it'll be the sentence of this court then on count 1 and count 3, defendant serve a term in prison on each count of 9 months. I'm going to run those terms consecutive to each other for an overall prison term of 18 months in prison. You have credit for 56 days you've already served. You need to advise you upon your release from prison, you'll be placed on post-release control for 5 years. If you violate any of the conditions of your post-release control, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50%, or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court will dismiss count 2 as agreed upon. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, transfer to transitional control. Defendant's ordered to pay all costs. Court further finds that consecutive service is necessary to protect the public from future crime by the defendant and to punish the offender, that it's not disproportionate to the seriousness of your conduct and to the danger she poses to the public, and that these two offenses were committed as a part of one or more courses of conduct, and the harm caused by these two offenses was so great or unusual that no single prison term for either of the two charges committed as a part of the course of conduct adequately reflects the seriousness of the defendant's conduct. Mr. Leslie, is there anything else I've omitted or that I need to address?
No, Your Honor. Thank you.
Ms. Thomas, on behalf of the defendant.
Nothing further, Your Honor. Thank you.
All rise.